May it please the Court, my name is Candy, initial T, Counsel instructed by Legal Aid Queensland, and I appear on behalf of the applicant, Mr. Beetson, in this matter. Your Honour, Mr. Beetson is charged on indictment pursuant to the Criminal Code with 5 counts of breaking and entering and committing an indictable offence and 32 counts of burglary. The application today is made pursuant to section 590, A, of the Criminal Code, seeking to have the applicant's admissions excluded from evidence in accordance with section 130 of the Queensland Evidence Act. It is submitted that in light of the officer's conduct on the date of the applicant's arrest, and due to cultural considerations, the court ought to exclude this evidence on the grounds of the Ireland public policy discretion, or in the alternative, on the basis of the Christie fairness discretion. The following submissions will be made regarding the Police Powers and Responsibilities Act. Your Honour, I seek leave to henceforth refer to this Act as the PPRA. Section 421 of the PPRA requires that where a police officer reasonably suspects their interviewee is a child, that is, under the age of 17, questioning should not proceed unless, where practicable, the child has been allowed to speak privately with the support person of the child's choosing. Your Honour, in accordance with the transcript of conversation between Mr. Beetson and the 2 officers, which took place on school grounds, the officers referred to the applicant on approach as, quote, young fella. So it would seem uncontroversial then, Your Honour, to suggest that the officers at least reasonably suspected that Mr. Beetson, a 14-year-old boy, may have been a child of law. Your Honour, the record of interview shows that the applicant was not afforded the right to a support person when being questioned in the police car. However, whilst Mr. Beetson was provided with a support person when at the station, similarly to the case of the Crown and L, at no point was Mr. Smith chosen by Mr. Beetson as required. Compounding this is the fact that the advice of Mr. Smith to the applicant was to the effect that the applicant had no choice but to answer the questions asked of him, Your Honour. So I now turn to section 431 of the PPRA, which requires that before any relevant person is questioned, they must be cautioned as to their right to silence in the manner prescribed under Division 5, Section 26 of the Police Powers and Responsibilities Regulation. Relevantly, subsections 4 and 5 of Section 26 require this caution to be repeated if there is any interruption in questioning, as in this case, or in the presence of any other person who is required to be present, such as a support person for Mr. Beetson. Your Honour, the importance of the underlying right here to have the ability to choose whether or not to speak to police was highlighted by the High Court in the Crown and Swaffield. Further, section 418 of the PPRA requires officers to inform a relevant person prior to questioning of their right to communicate with a friend, relative, or lawyer. Pursuant to the definition contained in section 415 subsection 1 of the Act, it is submitted that upon arrest for questioning regarding an indictable offence, Mr. Beetson became a relevant person, Your Honour. As the record of interview shows, at no point prior to questioning in the car or at the station was a caution issued to Mr. Beetson in the manner required, and nor was the applicant informed of his right to communicate with a friend, relative, or lawyer. Your Honour, the creation of a discretion to exclude evidence on the grounds of public policy, where evidence is obtained improperly, was considered by the High Court in Bunning and Cross, in which 5 key characteristics were identified. Firstly, it is of relevance whether the conduct was a result of genuine mistake or a deliberate breach of the law. Whilst it is accepted that there may have been no malice intent on the part of the officers concerned, there was nevertheless a series of substantial departures from common protocol, Your Honour, which when viewed as a whole must amount to more than mere mistake. Due to the essentiality of the evidence to the Crown case, it remains requisite to consider its cogency. In the interest of time, I refer the Court to my earlier submissions regarding the PPRA, and in light of the seemingly calculated disregard of the law by the officers concerned, and the cultural matters to be discussed, it is submitted that the evidence has such low cogency, Your Honour, that its essentiality to the Crown case should not preclude its exclusion. The third factor requires a consideration of the genuineness of the officer's actions. And Your Honour, it is submitted that there are simply no facts to support the assertion that the circumstances called for the reckless cutting of corners by the officers. In consideration of the gravity of charges, Your Honour, although indictable, it is submitted that the offences concerned are of a different nature to the violent and sexual offences contained in the Criminal Code, and thus the applicant does not pose a risk to the community of the kind that would justify denying the exclusion of evidence with such low cogency. As to statutory considerations, it has been submitted that there were substantial departures from the requirements of the PPRA. Per section 5, subsection E, one explicit purpose of the Act is to ensure fairness to and to protect the rights of persons against whom police officers exercise power. Your Honour, as enunciated in the Crown and Appleton, there is an important public interest that the police do not adopt tactics designed to circumvent a defendant's procedural rights. It is submitted, Your Honour, that the impugned conduct is of exactly the kind that legislation was in place to prevent, and as such, the balance of considerations falls in favour of the evidence's exclusion. In the alternative, it is submitted that the Court ought to exercise the Christie fairness discretion, and the Crown seeks to rely, Your Honour, on the admissions of a 14-year-old Indigenous boy who exhibited behaviour consistent with his cultural background in the presence of authority. This is primarily evident through a lack of eye contact and an avoidance of direct questioning. Your Honour, it is submitted that on page 3 of the transcript, there are signs of gratuitous concurrence consistent with the definition provided in Chapter 9, Part 4 of the Equal Treatment Bench Book of the Supreme Court on the part of the applicant. These cultural factors were either not identified or worse, misinterpreted by the officers, Your Honour, who then proceeded to deny the applicant several procedural rights set out by the PPRA. Further, Your Honour, the record of interview contains sections that are listed as inaudible, which it is submitted is non-compliant with Section 436, subsections 2 and 4 of the PPRA, and relevant to fairness as held in Butera and the DPP. Whilst pursuant to Section 439, the Court may still admit non-compliant recordings, it is submitted that doing so would not be in the interests of justice in this instance, Your Honour, due to the conduct of the officers and the cultural factors discussed. Overall, it is submitted that in light of these considerations, the probative value of the admissions, Your Honour, is substantially outweighed by their likely prejudicial effect on any jury as confessions of guilt, and thus the Court ought to exercise the judicial discretion to ensure fairness in the proceeding. In closing, I draw Your Honour's attention to Foster and the Queen, in which the High Court highlighted that a combination of both discretions may be used to reject evidence due to their inherent overlapping. Your Honour, that concludes the applicant's submissions.